This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
We have some questions here today. So the first question, what should be done if the HOA management and board set a budget that they know they will not be able to meet? They back into the numbers, like lowering the water budget to $30K, less than actual to accommodate another expense line. I'm a homeowner and a past president, and I know exactly what's going on. Okay, you're right. That's not right. They shouldn't be doing that. They're not running it like a business, right? So they're setting a budget that they can't meet. And they're probably doing that because they don't want to raise the assessments. So I think that as a homeowner and with your experience as a past president, you may want to write a letter to the board explaining that this is going to cause a shortfall in money at the end of the year, and that the water budget doesn't appear to be going down unless maybe they're not going to be doing the winter lawn or whatever. Ask for more information. Maybe they have justification, but it doesn't sound right, and it sounds to me like there's going to be a shortfall. So what do you do if they continue to do this and it's obviously going to result in a shortfall? Express your concerns to the board in writing. Consider running for the board. I don't know if this is serious enough to warrant doing a removal petition for your board. That's a consideration, an option. I'm not really sure this rises to the level of suing the board, but I think it rises to the level of documenting it, considering you run for the board yourself, and asking the board to be more responsible. Next question. What are the best methods or practices of communicating with owners and encouraging their voice and participation in budget strategizing? If there's really no interest from homeowners and all decisions are left to a very small board, what are your ideas for creating a culture of involvement and ensuring the best attendance at board meetings, especially those involving budget assessments, etc.? Okay, what I would do is, if you're a homeowner and you want more information on this, ask the board to have a town hall on it, or ask the board to put on their agenda a discussion of the budget. Now's a good time to start asking about that, and hopefully the board will do that. You may want to ask to meet with the board treasurer or the board president, or maybe the management company individually if you want more information. As a community, you could send a letter to the community saying, hey, it's important for us to be involved. The board's going to be discussing this at the October board meeting. Please attend. You might put it on Facebook or whatever, next door. Let the board know you want to be involved. Remind the board they have to be discussing this at open board meetings and voting to approve it at an open board meeting, and that if there are questions from the owners, they need to be addressed under the law before the board takes final action to approve the budget. But recognize too, you're an owner and you're not a board member, and ultimately these decisions lie in the hands of the board. So if you want to be more involved, the best way to do that is to run for the board. Okay, next question from one of my favorite clients. Given board members' lack of expertise in roofing, major repiping projects, and especially in view of the Florida condo collapse, it seems reasonable to mitigate personal risk and HOA risk by engaging qualified expertise. What can be done to encourage board members that guidance from specialized experts is essential in today's climate? Great question. What can we do to encourage it? You can share this video. It is important that boards that don't have any expertise in roofing or major repiping projects, that they're reaching out to their attorney to get the contract reviewed before you sign it. That maybe you have a construction expert on site, managing the project depending on how large it is. That may be something that's a good idea. I have a number of associations that have done re-roofing projects, and they hire a roofing consultant to manage the project to make sure that everything is being done properly. These are all great ideas. Checking the references of the people that you're hiring to do the work, making sure that they're in good standing with the registered contractors, that they haven't been sued, that they're, in good standing with the Corporation Commission. So reach out to your attorney, reach out to experts when you're doing large capital improvement projects to make sure that they are doing it properly. What are your feelings regarding an attorney attending a 4-hour association meeting due to the president's insecurities? Homeowners are paying for that. I'm chuckling to this question. The attorney really should only be attending the board meetings if a majority of the board wants that, right? Because there's an expense for the attorney to, go to a full 4-hour board meeting. Fortunately now, due to COVID, one of the positives of COVID is that I attend almost all my board meetings now via Zoom. And what we do is either the board member or the manager just gives me a window and says, we're going to have you, participate in the meeting during this window, and we'll text you when we want you to hop on Zoom. That way, I'm not charging my travel time. I'm not charging to sit there while they're, doing other things that they don't need me involved in. And so that's probably a better way to manage the attorney's fees expenses, is if you're letting the attorney appear either by telephone or by Zoom. Do I think it's a good idea for the president to have the attorney there to back them up? In some cases, honestly, yes. Some cases, the board does need the attorney there, especially if they've got a real serious issue with an owner or a group of owners. Is it necessary for me to be there for 4 hours, like you said? I don't know. It depends on what the issue is. Sometimes, yes. Sometimes, no. And I think what I would do as a homeowner, it sounds like you're unhappy about this, is you may want to frame it to the board in this way. We don't think it's a good use of association funds for the attorney to come for the length of the meeting. And we would recommend to be more fiscally responsible. Pass it on to the board. If you are unhappy, make change, run for the board. And then you can be setting the policy for your community. Okay, is it legal or acceptable, is the next question, to use reserves to fund a deficit? That's a double-edged sword, right? Okay, so do I think it's a good idea to use reserves to fund deficits, so to pay for things that you don't have enough money to pay for? No, it's not a good idea. It shows that there's some problem in your association, that you don't have enough money to meet your regular expenses, and now you're dipping into the reserves to pay for regular expenses. Is it legal? It depends. Check with your CPA. Check your association documents. Have I seen it done before? Yes, many times. Typically what the CPA will say is you should return the money in the same fiscal year back to the reserve to pay it back. So is it done? I have seen it done. It shows, it's a warning sign that things need to be evaluated. Why did this happen? And how can we prevent this from happening in the future? Next question, can the association have a higher assessment for rental properties due to added costs for security, specifically short-term rentals? Short answer on that would be no. What are your thoughts about an HOA taking out a loan or setting up a line of credit to pay for a large expense, like a number of leaky roofs, without doing a special assessment of all the owners? I guess my thoughts are, I don't know what the financial circumstances your association is facing right now. I don't. So, my feeling is I'd want to find out more information. Have associations taken out loans previously to fund repairs? Absolutely. We have seen that many times in the past. Typically there is a reason for that. Maybe they can't get the special assessment passed, and the only way that they can repair the item that needs to be repaired is to get a loan. And typically the loan does require a vote of the membership for the association to take on that indebtedness. You have to have your attorney write a letter to give you an opinion on whether your documents specify that, but most do. So what are my thoughts about taking out a loan or a line of credit to pay for a large expense? It happens. It's not something that, I see every day, but I've, probably seen hundreds of associations do it over 25 years. Usually it's not done unless there's negative feedback from the owners if they don't want a special assessment, or, maybe the cost of the repairs is so large that they have to do a hybrid, like part special assessment, part loan. So my thoughts are on it, it happens. But I think we need to dig deeper and determine why we're doing it. And is it a good idea? Understand the expense, the additional expense of the interest and the costs of the attorney's fees to help you through that process. And it might be something your association has to do or wants to do, because of the benefits of it. So my thoughts are, it depends on the circumstances. Okay, next question. If the accountant says that there are no additional expenses and the current amount of assessments meets all expenses, should the board still increase the assessments? Go back to that budget checklist that I gave you and, think about things, okay, so all of our expenses are going to stay the same. But do we have any large capital improvement projects that we want to do this year? Or do we have deferred maintenance? And that may be a reason why you still increase the assessments. But I mean, just saying that, we've done the evaluation on everything, and should we just automatically do a 3% increase when we don't really need it? No, I'm not saying that. I'm saying, think about the budget, think about your expenses, think about the income, think about your long-term projects, think about what needs to be done in your community, and try to make the best decision you can after strategizing on all those numbers. Next question, my HOA bills assessment. My HOA bills assessments quarterly, approximately 30 days before the beginning of the calendar quarter. On the HOA's 12/31/2020 CPA compiled financial statement, the balance of the operating fund, cash and cash equivalents, is less than the balance of the operating fund prepaid assessments. Presumably, first quarter 2021 assessments are paid in 12/2020. I read that the HOA has to utilize the difference to cover operating expenses in 2020 from proceeds of the first quarter 2021 assessments paid in 12/2020. This suggests insufficient cash flow for the prior year. Should this raise concerns on the part of the board and on the part of the homeowners? That would be a really good question for your CPA. I'm not a certified public accountant. I have financial background. I run my own business. I've got a master's in business too. Not necessarily is it raising a concern, because this happens in almost every association where they prepay, the January 1 assessment. But get some feedback from the CPA and see what your CPA for your association says. Okay, if you're a homeowner asking this question, you can ask for a copy of the financial statement and consult privately with your own CPA too. What's the difference between the bylaws and the CC&Rs? So we have a great cheat sheet just on this topic, right? It's called What is an Association? You can find it by going to our webpage, mulcahylawfirm.com, going to our cheat sheet tab and clicking on What is an Association. But basically, the difference is that CC&Rs have use restrictions for the properties. The bylaws establish the procedures for the internal governance and operation of the association. So CC&Rs are how the property can be used, assessment obligation, what type of insurance you have to have, who maintains what. The bylaws talk about how to run the association, when the annual meeting is, how many board members there should be, what the potential roles of the board members are, individual directors, what are the duties and responsibilities of the board. It's the internal governance is the bylaws, the use restrictions run with the land, and the CC&Rs. Okay, if your governing documents talk about funding a reserve, does that mean that your condominium association is required to fund such a thing, even if Arizona law does not? Great question. Yes. If your CC&Rs or your any other governing documents put in there that there's a necessity to fund a reserve and have a reserve account, you must do it, because that's a private contractual agreement that your association is bound by in those documents. Similar to your situation, I have found some issues on how the management company and our president handle our money. After an older treasurer tipped me off that our president was getting kickbacks from our vendors, I started to look into our financials. I came across $5,000 separate transactions where we didn't have an invoice or a receipt. I also found that we had several $1,000s and only had a self-made invoice from the president to the management company saying, I did this and I paid cash, so I should get reimbursed for $800. What do you recommend the association and or myself do? Okay, I mean, I don't know if you're, on your board. It sounds like you are, because you came across these transactions without invoices or receipts. I don't know how far back this is either. I don't know if this is 10 years ago, 15 years ago, last year. I think at this point, you should ask the management company. I'm assuming it's the same one. That was the management company that was, managing your association when these irregular things came up, for more information. What was this regarding? What's your position on this? And hear the response. And then you should take it back to the board. And maybe you need to reach out to your association's legal counsel to find out more information and to strategize as to whether it's worth it to pursue it. Now, I'm going to tell you straight up that sometimes I look at some of these things as your association's attorney and I say, okay, it looks like there was probably, 1,000 or two that, there's no backup, it's questionable. But we didn't find anything else. After turning over the stones and kicking the tires and looking at everything really carefully, we only found this. While it's wrong that there isn't backup documentation, and while it's wrong that it appears to be wrong that this person was paid this, it may not make financial sense to go after that person, to go to the police, because the police honestly is not going to do anything over that small amount of money. And you can go to small claims court. We can talk through the options, but it may not make sense to blow this up into World War III. And you also should be reaching out to that former president and ask for what his position is on it or her position is on it to get the full 360 view. So it's hard for me to recommend, other than ask for more information, and talk to the board about it, see if you want to get legal counsel involved, and then try to make the best business decision possible for your association. Okay, next question. Can reserves be used to replace clubhouse furniture because it is not functional? Can the board make that decision? Check your reserve study. Maybe you don't have one, but typically clubhouse furniture is going to be something that is included in the reserve. Should the treasurer or the board members ask management rep for actual bank statements each month? I don't know of anybody that actually gets to see, I don't even get to see them for my association, the actual, one that comes in the mail. Should you ask for it every month? You could go in and spot check and say, hey, I'd like to see the folder of the actual ones, maybe once or twice a year. Maybe you get electronic access to the associations, to be able to see the association's bank accounts electronically, and then you can cross-check to make sure that what they're giving you is correct. I think that's fine. But doing it every month probably is a little bit overkill. But if you feel that there's something not right going on, certainly you should go in and investigate further. What are your suggestions for addressing homeowners' concerns during an open meeting when they question transparency? By the way, the homeowners have reason to be concerned. Okay, so I don't know if this person's a board member, if this person's an owner, but how do we communicate with owners during an open meeting when they claim that we're not being transparent as a board? I think, and I just had a discussion on this with somebody yesterday. I guess my thoughts are, as a board, the secret to be a successful association is to communicate well with your owners, to be transparent, to answer the hard questions, to have justification if you can't provide information. And so if you're a board member and your board isn't doing that and you're just one seat on a 5-member board, I think it's okay for you as a board member to say, hey, I don't think that we are being transparent enough, and just have the record reflect that. Meaning you can say it at a meeting, or you can send an email and ask it to be placed at the records of the association. If you're a homeowner and you want more information, you can make records requests yourself, You can get an attorney that represents homeowners to contact your board to get more information, to demand that they be more transparent. You can ask them yourselves. I mean, it just depends. Every board has a different personality. And unfortunately, some boards like to play hide the ball. And I don't know why, because it's really not smart. It causes way more problems in the end for the board. And it causes a level of distrust in your association. It's better to be transparent. Successful associations have nothing to hide. They're reasonable, they're nice, they provide documents, they try to explain why we can't give you more information regarding a lawsuit that we're in. And they really can't. If we're in the middle of litigation, we cannot give you our strategy to settle the lawsuit. Okay, that's why we're on the board. That's our job, to make good decisions. We will tell you what the final result is at the end, but there will be some things we can't share with you. So I guess that's just my feeling for transparency and how you can best navigate that as a board member or as a homeowner. Okay, next question. What do you advise boards to have when do you advise boards to have a formal written contract drawn up before it expends HOA funds for goods or services? Is there a particular dollar amount above which there should be a written contract and not just a purchase order? Well, I think, the statute of frauds in Arizona says, anything over $500, that would be a good, starting point, I would say. So, if you are, getting goods or services and you're spending more than $500, that would, in my opinion, you should have something in writing documenting the respective rights and responsibilities. Now, I mean, if you're buying, some cleaning device and it's $2,000 and you're getting it on Amazon, I mean, okay, so that's a different situation. I'm going to make an exception on that rule. The board approves it, the manager, board member shows the picture to everybody, shows that it's on Amazon. Everybody talks about the fact that we need it, we vote on it, they buy it. Okay, move on. But if you're, entering into a waste removal contract, please reach out to your attorney and have us review that contract, because those always have a bunch of mines, and landmines in there that are difficult for associations to get out of the contract. Or we're seeing a lot of internet and communications companies reaching out to boards with new contracts, and there's some tricky little provisions in there that you need to get advice on. So make sure that you're not just signing it, that you're sending it off to your attorney to look at it. Your management contract, make sure your attorney is looking at that and giving you suggestions that are going to be helpful to save your association money, and so that you are getting the services that you should be getting. So those are just some suggestions, on how to handle contracts for goods and services. Our last question is, we are a small community. How much should we expect to spend on an audit from a CPA? We only have 4 or 5 bills that we pay through the year, so it's not all that complicated. Okay, so really what you should do is just reach out to a couple CPAs and just get a bid. My guesstimate, based upon looking at a lot of budgets and having been through the audit process myself, is it's probably going to be somewhere between $2,000 and $5,000. I know that's a lot. What you might want to do if you're a small association, you only have 4 or 5 bills, is package up 3 years of financial records and tell the CPA to randomly select a year to audit. And that way, it might be more cost effective. Obviously, if it's in your bylaws that you have to have an audit done by a CPA every year, there's really no way around it. You have to spend the money. You can't do that little 3-year thing that I was suggesting for the random audit. It could be lower, and maybe you don't do a full-blown audit. Maybe you just do a compilation or a review. So I hope those are some good suggestions for you. That will cost significantly less. That might be less than $1,000. I know you're going to have to get the bids yourself to see what the going rate is. And if you need names of CPAs that do accounting and audits for associations, please feel free to reach out to me at bmulcahy@mulcahylawfirm.com. Okay, great class today. We covered a lot of financial topics pertaining to associations. And I think this is going to be one of those videos that people are going to share with their boards after this class, because it just contains a lot of great information about financials, budgets, what you should do to protect your association, what are your monthly obligations to make sure that everything is, running properly from a fiscal standpoint in your association. So thanks again for joining us today for our 9th class of our 2021 Virtual HOA Academy. I'm really happy that you were able to join us here today. We had over 100 attendees via Zoom and via Facebook Live. I want to just take the opportunity again to thank the neighborhood services departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their teamwork, commitment, and continued partnership with our firm to put together these amazing virtual classes. We have had 47,000 residents or people throughout Arizona listen to these videos live and in person, and I really feel like we're making a difference providing free education. So I would like to thank those cities for their leadership and helping our firm put together these classes so we can have less problems in associations, better communities working together, following the law, and basically having less hassles as a board member, and maybe owners that are less frustrated about what's going on in their association. I'm going to be teaching a number of other classes. You can find all of those classes on our website at mulcahylawfirm.com. Just click on our seminars tab. And we hope you'll join us because we have a number of classes planned for the rest of 2021. One class per month with the Neighborhood Services Virtual HOA Academy. We're going to be doing, it's always the third Tuesday of the month in October, November, and December. And we have a sprinkling of other classes, including our First Fridays, which is the first Friday of every month between 9 a.m. and 10 a.m., where I go live and answer questions from anyone who has questions regarding HOA or condo law. So hope you'll be joining us in one of these upcoming classes. Thank you so much for being here today. Thank you for caring about your communities. And it's just my pleasure to be able to know and teach these classes with all of you. So have a great rest of the week. Hope to see you at a future class in 2021. Take care.